thank you, Eagle Forum, for letting me participate in this great conference that you're having. You see on the slide here, there's a website, a URL to the Social Science Research Network, where my full paper is available for download. You just type in that and hit the button for download. If you're having difficulty sleeping at night, I guarantee you this will help you overcome that. Additionally, if you go to the Eagle Forum events page, scroll down through the speakers. Since my last name begins with W, I'm the last one, so it's easy to find. Click on my picture, and a 4 or 5 page summary of the key points will pop up there. So you've got access to much more. I'm going to give you a drink of water out of a fire hose here, so we'll run through this rather rapidly now. But the material is available for you to peruse at your leisure. James Madison, the father of the Constitution, was asked in, well, I just lost the slide here, was asked in 1788, just a little over a year after the Constitution was submitted on the 17th of September, 1787, he was asked whether they should convene another convention to consider adding a Bill of Rights to the Constitution. And this was his reply. He was there on the ground as part of the Philadelphia Convention. We know him as the father of the Constitution. He raised objections and concerns in Philadelphia when the very first time the idea that a convention process of amending the Constitution was proposed. Now, certainly there needed to be a way to amend the Constitution. The Articles of Confederation were wholly inadequate to govern the new country. The amendment requirements for the Article of Confederation were quite severe, required unanimity amongst the colonies. And so there needed to be an amendment process. But when the idea of a convention was proposed that ultimately turned out to be accepted in Article 5, Madison raised several objections. And those objections, I think, are still pertinent today. In fact, I think they may be more appropriate today than they were in Madison's day as well. Let me change the slide here. Madison objected to the convention method because the congressional method was much simpler. You didn't need a convention. You didn't need any member of Congress, from Senator Lee, who spoke to us last night, to a member of the House of Representatives, can propose an amendment to the Constitution. And when 2/3 of the House and Senate approve it, it goes to the states for ratification. Much cleaner, neater, simpler process to do that. The convention method itself, Madison viewed, created divisiveness because of the wide variety of political philosophies that would naturally flock to such a convention. Lobbying groups, pressure groups that we see more sophisticated nowadays than perhaps in Madison's day. But the divisiveness was an issue that concerned him. And then, of course, I can get the next, there we go. His bottom line was, because the convention really revolves around the nature of the delegates, in other words, the men and women who would make up the convention, that ultimately, despite some of the laudable policy goals, and remember, this is in the context that Madison is talking about of the Bill of Rights, the laudable policy goals that virtually everybody agreed upon, that because of the nature of a convention and how they worked, that it could do more harm than good. Those were Madison's concerns when he expressed his reservations over this whole process of a convention method. The folks who are proposing a convention have some very sophisticated and well presented arguments. Can you push the next? There we go. So I'm going to run through this real quick. You can get the details in the paper, so we won't spend a lot of time here. The problem with not having a convention method was that if Congress blocks it, if Congress doesn't want to do it, then it won't get done. So the idea of a convention method was a way to get around a recalcitrant Congress, which is could very well be a real roadblock to significant reforms. But the real question is, what's the downside? The downside is, as Madison noted, the divisiveness that it would create. And I think we see that playing out now. We have conservative groups on both sides of the issue. So even within, we're catching up. Okay, I'm going to let if the guys in the back can catch us up, fine. If not, we won't worry about it. I'll just go off my own crib notes here. Let's talk very briefly about the arguments or the theories that Convention of the States and other proponents of an Article 5 convention would are proposing. They first of all, I think, assume their own arguments. And once you assume your own argument, it's pretty easy then to appeal to authority and convince other folks that that your cause is righteous. The first thing that they do is they say that an Article 5 convention for proposing amendments is the same thing as a convention of the states, which was a well-known convention process for resolving disputes and working through conflicts and within regions or among states. Well, they're right about the Convention of the States being a well-known entity used in the founding period and since, but there's nothing in Article 5 that says a convention for proposing amendments is a convention of the states. When pressed on that issue, Professor Nadelson, one of the most prolific commentators on Article 5 in the country, when pressed on that issue, he said, well, there was no need for them to say that because everybody knew that it was a convention of the states. Well, James Madison didn't get the memo because when this whole idea was first proposed, James Madison said, wait a minute, time out. What is this convention for proposing amendments that you're talking about? How will it operate? Who's in charge? What's the effect of its work here? This is a strange sort of thing to be throwing in the Constitution and going forward without any further explanation. And there's nothing in the historical record of the Philadelphia Convention to show that Madison's concerns were directly addressed by the other delegates in the convention, either then or during the ratification process. That's why when the Constitution was sent out for ratification and a little over a year later, when Madison was asked about the advisability of convening another convention, he said, no, I don't think that's a good idea at all, because those concerns had never been addressed. And I suggest to you that they have not been addressed yet, 230 some odd years later. So when the proponents here, we've sort of caught up. Let me see if I can catch up with the slides here. Madison's concerns over the delegates at the convention were a primary basis for his objections. And I suggest to you that if you look what he said, he's talking about the human heart. He's talking about our sinful nature, isn't he? And you know what? I don't think the human heart or man's sinful nature has gotten any better over the last 230 years. I think it's just as bad today as it was then, maybe even worse. So don't let the opposing side assume their own argument. Don't let them say that an Article 5 convention is a convention of the states, because once you've established that, once you're fighting on that ground, then all of their other arguments flow from that assumption. The next thing they said is a convention of the states can be limited in scope and in topic. The idea here is, well, when the 34 states, if they'll all submit identical applications to Congress and limit the scope of the convention to certain topics, then there's no problem with bad amendments being proposed. Well, one of the things that's pretty clear is that a convention under Article 5 for proposing amendment is a deliberative body, like a legislature. And what happens in legislatures? There's horse trading, there's deal making, there's compromises, there's smoke-filled rooms. Things get reworked in the process. And I give this example just to illustrate how a topic limitation, even if we say, okay, have it your way, you can limit it to a topic. Well, let's think about that. House Bill 3590 was passed by the House of Representatives that offered tax credits to first-time military home buyers. It was a tax bill. Passed the House, got to the Senate. Then Senate Majority Leader Harry Reid, through the amendment process, and as he could do, stripped out everything in that bill except the bill number. And he inserted what we colloquially know now as Obamacare. The Senate passed it. It went back to the House passed it, and we have Obamacare. Well, wait a minute, what does that have to do with a single topic? Well, if you recall, several years later, when litigation over the constitutionality of the individual mandate in Obamacare was litigated, and the Supreme Court decided, well, the individual mandate was not a fine, was not a penalty. What was it? A tax. H.R. 3590, as it started out in the House, was a tax bill. As it ended up in the Senate, was called Obamacare. What is it? It's a tax bill. Same topic. Two totally different policy outcomes, absolutely polar opposites, no relation whatsoever, but it was the same topic. So even if a convention could be limited, there is absolutely no guarantee that the policy that's going to come out of it is going to be anywhere close to what you thought about going in. The other point that they make is that the delegates can be controlled by the state legislatures, just like we can control our senators and representatives in Congress, right? And some states have actually passed laws that purport to apply criminal penalties to a delegate to a convention for proposing amendments that doesn't vote in accordance with the legislature's instructions going into this thing. Well, because of the deliberative nature of a convention, trying to craft an enforceable criminal statute that gives fair notice to the conduct that's prohibited is virtually impossible. You know, there's this debate that has taken place over the years about whether the Philadelphia Convention of 1787 was a runaway convention, whether it was limited to revising the Articles of Confederation, or whether it had authority to throw the Articles out and create a whole new system of government as they did. And I suggest to you that debate itself, if you peel back the onions and actually look at what happened, reveals something about this notion of being able to control delegates to a convention. 3 states sent delegates to Philadelphia with specific limitations that they could only revise the Articles of Confederation. Out of those 3 states, it was a total of 10 delegates that were operating under those restrictions. In the final analysis, 3 of those delegates obeyed the state legislature. 70% said, that doesn't matter, and we'll write a new constitution. So when your argument is you can control these delegates, but history reveals that 70% of the time they don't obey, well, what kind of guarantee is that we have that that's going to happen today? Then they say, well, look, you people are raising all of these scare tactics about all the bad things that could happen and all these unanswered questions. Don't worry about it. We've got the federal courts that will give us the answer. Well, first of all, out of one side of the mouth comes the argument that the federal courts are part of the problem, right? So why would you go to an institution that's part of the problem to have it fix the problem? But you can try to sort out that illogic for yourself. I can't explain it any better than that. The other problem is, in reading some of their writings, Professor Nadelson specifically said in his book, The Law of Article 5, he said that these issues concerning an Article 5 convention are freely justiciable. Now, that's legalese for saying that, the federal courts have jurisdiction to hear these things and decide them on the merits. Well, first of all, that assumes that they're going to decide these issues in your favor, right? Yeah. Okay, I've been in federal court. You don't always get a ruling in your favor, okay? 50% of the folks in federal court are going to lose. You understand that? When you get into litigation. The other thing is the nuances and complexities of federal jurisdiction are such that there is no guarantee that a federal court would have jurisdiction over a specific event. And by saying that these issues are freely justiciable, either betrays an incredible naivete of federal jurisdiction or total misunderstanding of it, or an attempt to obfuscate some of the real issues that would preclude judicial review. And finally, they argue that, not to worry, because the ratification safeguard requires 3/4 of the states, 38 states, to ratify an amendment. So there's no problem, there's no chance whatsoever that a rogue amendment, a bad amendment would ever be ratified. So, don't go running around with your hair on fire. Well, if you stop and think about that, what are they conceding? They're conceding that these other arguments that they just made are false and will fail because they've got this fallback. Even if those things don't happen, Now, alternative pleading in federal court where you can make, Judge, my guy didn't do it, but if he did do it, he was crazy. If you can make those arguments in a legal setting in federal court, but they're not very persuasive in the court of public opinion because they betray an illogic. You can't have your cake and eat it too. The other thing is there's a huge lapse of time between when states propose or apply to Congress for an Article 5 convention and when a convention might be convened and its work completed. How many election cycles will take place in that period of time? How will the makeup of the legislature change? How will the issues that the public are concerned about change? Time has a way of creating problems like that. So again, there's no guarantee. And what was a rogue amendment 10 years ago, 15 years ago, 20 years ago, when some states first applied for an Article 5 convention, and what's a rogue amendment today is quite different. I mean, I'm so old that I can remember when profligate government spending caused inflation. But today, it cures inflation. So that's the kind of thing and I'll end by quoting that famous American philosopher, Yogi Berra. No, Yogi said, predictions are hard to make, especially when they're about the future. And so those are issues that I think state legislators must consider seriously and carefully when they're asked to vote on whether to apply to Congress for a convention for proposing amendments. And I don't think that's happened. I think the slickness and the unsupported confidence and assurances of some of the proponents have sort of overwhelmed busy state legislators, and they haven't given it the attention that the issue deserves. And I applaud Eagle Forum for being on the front lines in trying to bring truth on this issue to these legislators. Thank you.